Morning, everybody, and welcome to June's Employment and HR Coffee Break Briefing. This is session 3 of 3, looking specifically at the Employment Tribunal process and the practice. Obviously, last month's session, I know we had a few technical issues, particularly with using this platform. So apologies again for those of you who couldn't make it. It was unfortunately quite a good session in the end. Hopefully you've had a chance to get the recording, to get a copy of any transcript that might have been produced, and also even for those of you who did join, the slides that we had been hoping to show. We're back on our usual system today. We've definitely parked Teams for the time being, back obviously to go to, as you've noticed, for, as I say, what will be the last formal and structured session looking at the Employment Tribunal process. Today's session, as it says there on the screen, outcomes and beyond. So we've done the session sort of introducing the Employment Tribunal. I talked a bit about its background, the types of claims that the Employment Tribunal can deal with, and then last month's session, for those of you who are able to join us, we were looking at actually responding to tribunal claims being in the tribunal itself. And of course, I have the advantage of having Nathan join me as somebody who had been there other than as a lawyer. For today's session, the outcomes and beyond, so we will talk about tribunal judgments, awards, and the appeals process. I had been hoping that Nathan would be able to join me today. He's actually caught up on another piece of work. So the last couple of sections of today were going to be sort of learning outcomes and bringing maybe less successful tribunal results back in-house to talk about what can be done to mitigate future claims and future issues. I'll park that for a further session. I think that's the kind of conversation that, again, while I can talk about it from a lawyer's perspective, it'd be really useful to have somebody on the call who can also talk about it in-house and as the person who's maybe implemented those changes when there's been an outcome that maybe a business doesn't want. As always, sessions being recorded, it will be made available to all of you who sign up. It will also be on the Friends YouTube page. I can see the questions and Q&A much better than I could last month. So as always, if anybody's got any comments, queries as we go through, feel free to put them in. If it's something that I can address as we go, I will do so. If it is something that can wait until the end, or maybe not necessarily form part of the recording, then as always, I'll spend a few minutes at the end just going through what outstanding questions I can. So today's session then, the Employment Tribunal, let's say, outcomes and beyond. So I will talk through possible remedies. So we'll be assuming that as a business, as a respondent, we have lost the tribunal proceedings. What's the worst case scenario for a business here in terms of possible remedies? How a claimant enforces any judgment that might be made in their favour, and indeed that's equally applicable to potential counterclaims, for example, that an employer might have brought. I'll touch on costs in the Employment Tribunal, because as much as that's something we try not to over-concern ourselves with too much, can arise. There is a cost regime in the tribunal. Talking about reconsiderations and appeals, so that's the formal processes by which we can ask the tribunal to review a judgment that we might not be happy with and the basis for doing so. And then, as I said at the end there, I was intending to do lessons moving on mitigating future risk. I can still touch on those briefly, but again, I think that would be in detail a session I'd quite like to involve Nathan in as well, so that we can have more of a discussion and make that look more of a two-way process. So that's the outline for today. Again, because of course we've done 3 sessions on the Employment Tribunal, most of you will know we've got a mock tribunal event coming up on the 18th of June, so that's in 2 weeks' time. There are still a couple of places available on that, so if you're not yet signed up, do want to come down for the day, see us, meet us, watch a mock tribunal take place, with a handful of real barristers on board as well, and possibly watch us embarrass ourselves and our fantastic acting skills. Please do have a look on the website, and obviously we'll make sure details come out as part of the follow-up from today as well. Like I say, a few spaces on that left. It will be a fantastic session, and yes, there is sort of lunch and networking opportunity as well. Anyway, moving on to today. So obviously we are assuming that we have gone through a tribunal process, we've done the final hearing, and that unfortunately as the employer, we've not been successful in defending the claim, we've lost. And before we move on to remedies, there is obviously an outcome to consider. You'll get a liability judgment in the Employment Tribunal either verbally from the judge at the end of the hearing or followed up in writing before remedy is addressed. Naturally, that is simply a case of win-lose on each of the various points. A claimant is either successful in any given element of their claim or they're not. There isn't a middle ground in the employment tribunal. There's no sort of balancing act of, well, this was sort of discrimination. It either is and it fully meets the test, or it's not. On the back of that, of course, we then move into remedies, and the remedy most of us are familiar with is one I'll cover in more detail and spend most of this part of the session dedicated to, is the financial award that a claimant can win depending on the nature of the claim they've brought. But there are, of course, other options available to the tribunal, and the nature of the claim that is brought does actually dictate which remedies are available to the tribunal and in which circumstances. So as I've said there at bullet point 3, in an unfair dismissal claim, in principle, the employment tribunal does have the option to order re-engagement or reinstatement. Both of these are options available to the claimant on the claim form when they tick what they want. It is usually isolated to unfair dismissal claims, and that, of course, is either re-engagement on some form of employment contract with you, similar to previously, or on exactly the same job that they had before they were dismissed, if that job still exists. Reasonably rare, I have to say, for what I think are probably obvious reasons, partly because in an unfair dismissal claim, it may well be the case that we are talking about a judgment coming 18 months down the line from when this dismissal has taken place. The employee may well have had a new job by then, may well not be an option for them to return. And I think the tribunal are quite willing to recognise that after a year of litigation, the relationship often just isn't there. Where it does crop up occasionally is in sham redundancy cases, or where a redundancy process hasn't been followed correctly, where those hearings take place relatively shortly after a dismissal. Again, I think it's a symptom of the tribunal system more than anything else that we don't see re-engagement, reinstatement used more often. If hearings were happening 2-3 months after a dismissal, then I think I can see these as being more likely. Realistically, a year, 18 months, even 2 years down the line, we very, very rarely see them at all. And again, I think it's one of those cases as well where an employee will come to a lawyer and approach the tribunal with the view of wanting the situation corrected. They might say, I want my job back, I want the dismissal overturned, etc., etc. But actually, by the time they've gone through that process, by the time they get there, I think they recognise that the financial contribution to the process is then needed to be reflected in the compensation, more so than taking their job back with somebody who they've had an argument with for over a year. The tribunal does have power to make various declarations and recommendations. Again, that is an option available to the claimant on the claim form. It's something that can be put in a schedule of loss or a remedy schedule in due course. That is, in effect, the tribunal declaring that as an employer, we've breached the employee's rights. Usually in relation to discrimination claims, of course, it would be something to the effect of the employer is in breach of their duty to make reasonable adjustments, for example. Somewhat self-explanatory from the fact that a judgment says that you've discriminated against them. It does rather make one wonder why there needs to be a declaration as well. The fact that there's a written published judgment should be sufficient. And the tribunal, again, does have power to make recommendations about implementation of policy, training exercises, those sorts of things. Again, more common in discrimination claims. I think what I will say with these is they are reasonably rare in judgments that get all the way to tribunal, where there are declarations, where there are commitments to doing EDI training, commitments to introducing new types of policy. That is much, much more common in settled disputes outside of court, where the specific way that it's implemented, the nature of the obligation itself, and the ability to require the employer to feed back to the employee on it is something that can be agreed through mediated settlement in a way that the tribunal doesn't always like implementing. Forcing an organisation to introduce EDI training, to go to those costs, to go to those commitments, and the logical extension of that being to force other employees to engage in that process, starts to look a little bit like forced performance, and courts aren't huge fans of compelling people to do things. That said, it is a potential remedy, and particularly if you're a public sector employer, be mindful that that is something that an employee may want to pursue, especially if you've got an overarching duty under your public sector role or any contracted service to implement policies or procedures in a certain way. I said I would come on to financial payments, and I'll come on to sort of the substantive financial payments in a moment, but it goes without saying that where an employee wins a claim for things like unpaid wages, an unlawful deduction, a contract claim for non-payment of a bonus, or non-payment of holiday entitlement, the tribunal does have the power to make a simple financial award, calculating the balance of those. So the big ones, the big two claims that we're all familiar with and the ones we usually panic about most: unfair dismissals and any form of discrimination claim. And the reason we're mostly concerned about those is because they do carry potentially quite hefty financial remedies. Speaking about discrimination very briefly, just first in a general sense, when I advise an employee on this, as I've alluded to a moment ago, what employees often want is somebody to recognise that they've done something wrong, that they have treated the employee badly, and it's very, very common for an employee to say, all I want here is an apology. Now, that's a great place to start, but of course, the moment you tell them that the tribunal can't force somebody to apologise to you, and that in principle, the only way the courts and the UK legal system has of compensating discrimination is financial, the conversation does very quickly turn to what that number looks like. It is not unusual at all, and those of you who've been there and involved in particularly negotiation processes for settlement will know that an employee might start talking about their principles, but will very quickly end up talking about 20, 25, 30,000 pounds worth in settlement sums. That said, there is a logic behind it, and it is simply that this is really the only way that the court system does have of awarding wrongdoing by an employer. So, what do these awards look like? Unfair dismissal. Two ways that the Employment Tribunal really can award unfair dismissal. They all sort of form part of the overall calculation when it's being done at the end of a case. We've got the statutory basic award, which to all intents and purposes is the same calculation as a statutory redundancy payment. So weekly pay subject to the cap, multiplied by number of years employment, with the appropriate multiplier depending on the employee's age at any given time while they were working for you. And then separately, a compensatory award of, as I said there, up to 52 weeks pay, just reflected in weeks pay, of course, to account for irregular hours and people who aren't salaried, or a figure of approximately £118,000. That changes every year, depending which of those is the lower. So just to be clear, an employee on a £50,000 salary is not claiming up to 118,000, they're claiming up to 50,000. And that is a statutory cap. It is simply there. It's a year's salary or that figure. It's the top end for a basic unfair dismissal claim that can be awarded. And the intention of that payment is that it recognises the fact that an unfair dismissal claim, if established, is basically a highly regulated form of breach of contract. What the employee is saying is, you have unfairly breached my employment contract by dismissing me. You've brought it to an end arbitrarily in a situation where you weren't allowed to. So what I should be claiming for is my financial losses caused by that breach, which at a really simple level is a breach of contract claim. So we introduced this statutory cap, which says that's fine, you can bring financial losses arising from that breach, but only up to a year's worth. Now, on top of that, the Employment Tribunal is also expected to award both what is reasonable, but also only what is reasonable in the circumstances. So when an employee brings an unfair dismissal claim, the calculation will run something like basic award, fine, loss of earnings up to the point where they found alternative work or up to a year, less various other things that as an employer we get the opportunity to argue further. And these arguments around remedy are, to be honest with you, often just as heavy and just as strong as the actual liability arguments were in the first place. So when we're bringing a claim for loss of earnings, What we are always looking for in order to try and reduce that overall payment is things like, did the employee take up alternative work after they'd left? It doesn't matter whether they were unfairly dismissed or not. There is a general obligation on them to try and mitigate that loss. If an employee leaves under any circumstances and say they were on £20,000 and in 2 months' time they take on a new job earning £22,000, well, the losses really are limited to that 2 month period. There's no way they could have taken up that new job while still working for you. That opportunity wouldn't have become available to them. And they shouldn't be sort of double compensated. So there is that expectation that they will do that, and that new employment does also start to break the losses that are caused by the unfair dismissal in the first place. Where an employee doesn't take alternative work, that doesn't change the fact that there is a general mitigation duty on them, and it's something an employer can always raise. You should and could have tried to reduce your financial losses by seeking alternative employment. And when it's looking likely that an unfair dismissal claim will be brought, and some of you will be familiar with this because we've told you to do it, one of the first things we will say is keep an eye out on job offers that this employee would have been able to do within a reasonable distance of their home. And the reason for that is one of the best ways to prevent a tribunal from giving up to those 52 weeks pay is actually in a remedies hearing to sit there and say to the claimant, here's 50 jobs we think you could have applied for in the 2 or 3 months after you left. Did you? What efforts did you use to try and mitigate that loss? Did you try to seek alternative employment? And an employee saying no to that is in quite a difficult position. We're not responsible for them failing to look for alternative work. When we're talking about an unfair dismissal as well, there's a few other arguments that can always help us in a remedy judgment, particularly in gross misconduct, disciplinary dismissals. We can always argue the employee was partially responsible for their own dismissal. So even if the dismissal was unfair, we can say, well, yes, it was unfair, but they'd still done this thing wrong, or we still believed they'd done this thing wrong, so they were still partially responsible for the fact that they were dismissed and therefore their financial losses. And that process sort of works in the same way as the percentage of blame if you've ever been involved in a car accident. It's the best analogy I can give. The tribunal will do a somewhat arbitrary assessment of to what extent was the claimant responsible for their own dismissal. And part of that, for example, would be not engaging in a disciplinary process, even if that process was inherently unfair. We've also got the uplift or deduction for failure to comply with ACAS. So that's an important one to remember, particularly in a misconduct dismissal situation. Not having standards, not having a process or procedure that meets those minimum expectations set out in ACAS can see an employee's overall compensation increased by up to 25%. Tribunals do impose it, and if any other code applies to the dismissal process, they can also take that into account. So there will be one for sexual harassment in due course. There is, of course, one for disciplinaries and grievance processes at the moment, and there are expected standards that result in uplifts in due course for redundancy consultation processes as well. The final one that those of you who've been all the way through a tribunal might be familiar with is what we call the Polkey deduction. It's an old piece of case law, and the gist of it is basically, okay, we accept that the dismissal might have been procedurally unfair. We didn't follow process fantastically, maybe the investigation wasn't brilliant, but if we had followed a proper process, it might have taken us 2 or 3 weeks longer, but we'd probably have dismissed this person anyway. And then again, the tribunal will do an analysis of that to reach a decision as to the likelihood of that, how long it might have taken. And again, that can limit the losses. If we could have fairly dismissed in a couple of weeks, there is justification to say that a dismissal would have happened anyway. And therefore, for example, a 6-month loss of earnings compensation is not justified. Moving on to the scarier of the two then, discrimination claims, and it is perfectly natural to go into panic mode once we discover that a discrimination claim has been successful against us. And the simple reason for that is, as I've said there, discrimination claims are, in theory, uncapped in terms of how much can be awarded. There was talk during Brexit that that might be scrapped. It's an EU concept that there's not allowed to be a cap on discrimination claims. That hasn't happened, as you've probably noticed, and the law is still as it was prior to us leaving the EU. In principle, discrimination claims are uncapped. In practice, of course, we know that the injury to feelings element, the most common part of a discrimination claim, has these relatively informal caps on them. A claimant is supposed to argue, and a tribunal is supposed to consider a discrimination claim within the so-called vento bands. So what we're rewarding for injury to feelings is how badly the claimant has been made to feel by the discrimination. There is no scientific test for this. There's no absolute measure on this is a middle range form of discrimination, this is a low form range of discrimination. It's a very much subjective test as to how the claimant was made to feel, as against similar cases that the representatives or the judge may be familiar with. So that starts from quite a low band, a few £100, about £1,000 at the moment, up to a few £1,000s. The top end of that is in sort of the £50,000 area, really. Those top ends are usually reserved for sustained periods of quite serious discrimination, so daily harassment that takes place over a long period of time, or particularly extreme examples of discrimination where they're one-off events. Just from my point of view, for example, if discrimination leads to a dismissal in some way, my view is always that that would be somewhere in the middle band as a minimum. I don't see how any dismissal, even if it's the employee resigning in response to discrimination, can be considered minor discrimination. That said, there is scope for the courts to award above the top end of that vento band for exceptional cases. They can and do. It doesn't happen very often, definition of exceptional, but the scope is there. Where the really big awards in discrimination claims come from are financial losses arising from discrimination. This is a huge head of loss, which can encapsulate a huge amount of figures. Loss of earnings is a prime example that I'll come on to in a moment, but it does cover everything from loss of earnings through medical costs that might be associated with receiving treatment for the discrimination. In principle, it could include some of their legal costs, although that's quite rare, and we'll come on to costs shortly. And any other costs, I suppose, that they've incurred in trying to rectify the issue, to seek alternative work. It's awarded in a fairly broad way in theory. Loss of earnings, of course, is the huge one, and the best example that I can give of this is reasonably modern in the grand scheme, but probably for employment cases quite an old one now. Some of you will be familiar with it. It's about 5 or 6 years ago now. There was a primary school head teacher in Wales, I'm sure it was in Wales, don't quote me on that bit. Primary school head teacher either way, who had, as far as was pleaded, met up with 2 young men who he had met on a social media hookup app. I won't name them for various reasons. And it eventually materialised, he did have sexual relations with these 2 individuals, and it materialised that they were 17. Now, of course, that's perfectly legal, age of consent being 16 across the UK. So in principle, no major issue with it. But the governing body of the school and the local authority did take certain issue with the fact that these 2 individuals were under 18, and they did pursue quite a heavy disciplinary process against him that resulted in a gross misconduct dismissal. It was ultimately, yes, conduct-based. Conduct unbecoming was, I think, the phrase they used all the way through. They were concerned about the reputational damage to the school, to the local education authority at the time, and he was dismissed. He brought a claim for unfair dismissal. He also brought a claim for sexual orientation discrimination. Now, don't forget, he was a primary school head. There's no way that these 2 students were his students, thank God. And as far as anybody was aware, they'd never been his students. There are specific rules for teachers and anybody who works with young people or vulnerable adults about the amount of time that has to pass before you can have relations with them after you're no longer in contact. Of course, even if he had taught them 15 years earlier, it would have been a bit weird, but not in principle unlawful. So yes, he brought a sexual orientation claim on the basis that if it had been a heterosexual relationship in any way, the school would not have pursued it in the same way. His basic argument was, if I'd been a woman and had a relationship with these two lads, you wouldn't have pursued it in the same way. And the tribunal agreed with him. Various reasons that are set out in the judgment. I don't have time to go through it all in detail or why it was established that way. The tribunal agreed with him, as did the Employment Appeal Tribunal. Now, the overall point of this, of course, is that by this time, the damage had been done. There's no way he was going to work in education ever again. There'll be people on this call who will be thinking quite rightly, I'm sure. Some people may even agree with the local authority on this, but the point is he was successful in his discrimination claim. His overall award was about £700,000 because it accounted for career losses. So the point is, in a discrimination claim, these losses can be huge. They are rarely that big, but this is one of those exceptional cases where the tribunal accepted that the claimant had been discriminated against and that discrimination had impacted his entire future career. Beyond that, the tribunal does, in theory, have the power to make an award of personal injury. They don't like doing so because it overlaps with the injury to feelings element, and it's quite hard to distinguish between these are the emotional damages I'm claiming for the way I've been treated, and this is a psychological injury that you've caused me. If a claimant is pleading a personal injury, it is on them to prove that it otherwise satisfies the test. So that tends to result in a huge amount of medical evidence and often expert evidence that there has actually been a personal injury. The most common, as you can imagine, is you've caused depression, you've caused PTSD, etc. by the way you treated me. Generally, I think if that's serious enough to be framed in that way, you'll find the employee is bringing a separate personal injury claim against you in the civil courts. Aggravated damages does exist in the Employment Tribunal. It is the power to award an enhanced compensation award for a particularly heavy-handed approach to process or procedure. Where it's awarded, it's usually in disability and particularly mental health discrimination claims. And it's usually the claimant saying, not only was I treated badly in the act of discrimination itself, but the manner in which you dealt with it was particularly bad as well. So there might be a discriminatory act that leads to a grievance. The grievance itself is then conducted in a discriminatory way. Not only is that victimisation, but it could well justify aggravated damages on top because it's compounded the effect of the original discrimination. The last one I mentioned there, penalty payment to the Secretary of State. This is a specific statutory award that is in there for employers, respondents who perform some kind of public sector duty. It's not just limited to public sector employers. It is anybody who performs a similar duty. So care homes, private schools in particular will potentially fall under this definition. Anybody who performs a function that could be considered a function of the state. It's those who are subject to the Equality Act duty, the specific Public Sector Equality Act duty not to discriminate, and it is simply a penalty payment or a fine paid to what I think ultimately goes into the NI pot. Again, rarely claimed unless somebody's really trying to make a point, because of course it doesn't go to the claimant, so there's no real benefit to the employee in claiming it, but it is there, and it is a way of potentially uplifting the overall costs to an employer by a further few £1,000s. So they're kind of our big ones and how they're awarded. And like I said at the start, you can see why the remedy then becomes something that is as hotly contested as the liability judgment in the first place. With that scope for discrimination claims to be so high, the risk is there all the way until the end. So it is natural that remedy hearings can last a day, can even roll into a couple of days, depending on the nature of the calculations. Schedules of loss are complicated and can be complicated things, especially when you're claiming long-term earnings loss, pension loss, which form part of that £700,000 value. Personal injury claims, as I say, can rely on evidence, and then there's particular regulatory and statutory guidance about how much can be awarded. And it would be unsurprising that aggravated and penalty payments are particularly hotly contested by respondents. Other remedies then, there is a statutory payment regime for various specific claims, so things like breach of your consultation obligations in a TUPE or redundancy situation. They lead to specific set payments calculated based on weeks paid to the individual claimants. I've mentioned failure of a TUPE process there because it's not just the individual employees who have got potential claims. Don't forget, in a TUPE situation, the failure to provide the required information gives rise to a claim between transferor and transferee as well. So that's always worth bearing in mind. And there is a particular statutory award for failure to provide a Section 1 statement of terms of contract. That claim doesn't exist in isolation. An employee cannot just bring a "you haven't given me a contract" claim to the tribunal, but it is usually tacked on the end of another claim and can give rise to an extra couple of weeks' pay completely unnecessarily. Just give them a contract. As I said at the start, employees do often just want somebody to say sorry or admit they've done something wrong as a start point. The tribunal does not have the power to award that, and it's something that I find myself regularly advising employees when I act for them. The one thing that is very, very unlikely to happen here is anybody ever accepting that they've done something wrong. There's no reason for a respondent to do so. They might choose to do so after a tribunal judgment. The judgment might tell them they've done something wrong. But, I mean, logically, why would we then turn around and say, sorry, yes, we really got this wrong? It just doesn't happen. Enforcement process then. So we have had the judgment against us, or I suppose in principle we had a successful counter-contract claim and we've got a judgment against the employee. What options are available to usually them, I have to say, or potentially us? Well, firstly, it's worth noting the tribunal doesn't have its own enforcement powers. The judgment will be there, but it's a little bit meaningless other than as a judgment. You can't just take a tribunal judgment, hand it to a bailiff and say, go and enforce this. It doesn't work like that. So a claimant has to rely on one of the contractual enforcement processes in the same way as having got, for example, a CCJ. Now, there is a fast-track process through High Court enforcement. All the claimant has to do is fill out a form, provide a copy of the judgment, it gets rubber stamped as a writ and passed immediately to the High Court Enforcement Office, who will send their sheriffs out basically to enforce the judgment in due course. Not a pleasant thing to have happen to you. High Court enforcement do have entry powers, they do have seizure powers, so it can happen, it does happen. And therefore payment of the judgment is almost always preferable. Other than that, the claimant does in theory have other options available to them. As soon as they've got the judgment sort of endorsed by the High Court, they could in theory file some kind of charging order. So that would be either through land registry, for example, if you're a small business who owns the freehold to their property, they can put a charging order on that. Or through Companies House in a similar way to a floating charge. Limited value, of course, because the advantage of a charging order is that you get paid when the property is disposed of, or you create a problem for the individual if they try to mortgage it, for example. If a claimant wants their money and they take a charging order against the freehold that your organisation owns, there's no guarantee they're going to get that money unless and until you sell. They are also going to sit lower in the pecking order than people who, for example, already have a mortgage against you. So it doesn't happen very often, but in principle it can, and if the claimant's intention is just to be a nuisance, it's a useful option for them. And in theory, just like any other contractual debt, they can go down the winding up process, and they can start a winding up petition against you, which could ultimately lead to a compulsory liquidation of the business. Again, something we want to avoid, obviously. Now, what I will say about liquidation, and if the business does become insolvent as a result of a judgment, is the individual's tribunal claim value doesn't have any particular priority. So we know the priority debts in, and I feel like I'm straying into one of Malcolm Neakirk's insolvency coffee break briefings now. The priority of debts on liquidation sits exactly the same. The employee's tribunal award will sit no higher than any other contractual debt or payments of, for example, HMRC. So all of those priority debts, the secured loans, the mortgages come out first. and then everybody else just gets a share of what's left, if anything. I've had it happen both ways round to me. I've had it happen when I've been acting for a respondent, the tribunal judgment, they just simply couldn't pay it and had to liquidate. And I've had it acting for an employee as well, very frustratingly, where they went through a liquidation immediately after proceedings had resolved themselves. And in both cases, the claimant ended up getting next to nothing. I think it was a few pennies in the pound. Just as a brief detour away from actual tribunal judgments and awards, if you reach a settlement and it is signed on a COT3 through ACAS, there is also a fast track process which ACAS can facilitate to enforce that. So simply signing a COT3 doesn't get you out of this fast track process. A settlement agreement, by contrast, is just a contract. The claimant, if you don't pay under a settlement agreement, has to enforce that as a contract first, and then go through a formal enforcement process to get paid. But the ACAS procedure, if you sign a COT3, they've got a process very similar to enforcement of a judgment. It is just a different form. So that is an option available if you have settled and signed through a COT3. It's one of the benefits to an employee in signing a COT3 is that it's a quicker enforcement process. Moving on then, costs in the tribunal. Contrary to popular opinion, there is actually a costs regime in the employment tribunal. It is there in principle, it's just not one that gets used very often. I think it's fair to say that by default, the tribunal broadly considers itself to be a costs neutral jurisdiction. It's rare for there to be costs awarded one way or the other, and it's certainly not a default position that if a party loses, they will pay the costs of the other to any extent as it is in other jurisdictions. So like I say, it's less commonly used, and the value of those costs, even when they are awarded, tend to be less significant. There's two types of costs order in the tribunal: preparation order and wasted costs order. So even by their names, just taking their ordinary sort of definitions, it's clearly not I must pay all of the other side's costs. They're quite specific. Preparation time in terms of preparing for a particular deadline or for a hearing, and a wasted costs order in relation to time spent preparing or doing something which then becomes completely unnecessary. That's sort of the gist of both of them. But as I say, the threshold is particularly high in both cases, and it's not an easy test to meet. And this is that test. So this is broadly lifted directly from the legislation that allows for costs in the employment tribunal. You don't ordinarily make them until the end, although they can be made through the process if, for example, there's a particular hearing that doesn't go ahead because someone doesn't bother to turn up. So what we're looking for is the party you're trying to make the order against has to have acted vexatiously, abusively, disruptively, or otherwise unreasonably. And that can be in one of two situations. It's either by pursuing the claim in the first place, or the response, or the manner in which it is pursued. So a classic example with this would be a claimant brings a claim which potentially has no prospects of success anyway, but they do so simply because they are angered by the fact that they left the organisation, so they just throw in pages and pages of discrimination claim that has limited merit. You're probably going to do that as the second of these options, which I'll come on to in a moment, but that may also be considered a vexatious claim. Disruptively, probably a better example here. The most obvious way to act disruptively or perhaps unreasonably in the pursuit of litigation would be ignoring tribunal deadlines, ignoring directions, not turning up for hearings, not providing documents when you're supposed to, unreasonably redacting documents, ignoring correspondence from the other side, all of those sorts of things that just make the entire process more difficult, basically. That said, it is litigation. Lawyers in particular do enjoy being a nuisance. We are a nuisance to each other. We know how to toe the line and how to not fall into the category of abusive or unreasonable. Litigants in person don't always, individual clients don't always, and something that between us would be considered maybe perfectly normal. It's very irritating. I don't like doing it, but for example, that sort of 5 o'clock on a Friday email, that is not abusive, disruptive, or unreasonable. It's a nuisance, it's a pain, but it is not by definition going to be unreasonable. Option 2, as I was hinting at, that the claim, the response, or any form of reply has no reasonable prospects of success. So that, of course, allows for costs to be made either way, depending on the appropriate party. The claim was never going to be successful to start with because it was rubbish, because the facts weren't true, because there was no evidence. Or equally, you weren't justified in filing the response in the way that you did. That can give rise to a claim for costs on the basis that you've had to file a defence for a claim that was never going to succeed anyway. What you would probably do in that situation is simultaneously file for strikeout of the claim at a preliminary hearing and your costs. And the last one there, usually this is a good example of one of those sort of wasted time orders. A hearing is postponed on short notice, less than 7 days, and you can then say, I prepped for this, I was building up to it, I took the day off if you're an individual claimant to be able to come, and now I can't recoup that. My lawyer's done X, Y, Z in terms of building up to it. The tribunal rules do say that if you need to postpone a hearing for some reason, you should give 7 days notice where at all possible. Obviously, there will be extreme circumstances, there will be exceptions, family emergency, a death, something like that may mean that 7 days notice can't be given. Tribunal is not going to award costs in those situations generally. But for anything that was sort of foreseeable or predictable, failure to give that notice can lead to costs. As I say, as a general rule, costs are not awarded in the employment tribunal. You see, this is quite a high threshold to reach. It's not just you lost. And the principle behind this really is that because we're talking about fundamental statutory rights, unfair dismissal, discrimination claims, employees should feel free to bring what they believe to be a valid claim, even if they ultimately prove to be successful. And in any situation where a claim is issued, the company or employer should feel that they are free to respond to it as they deem necessary. So it is quite a high test, and it is designed to prevent abuse of the system and abuse of the process, more so than prevent people from bringing claims that are a bit sort of on the fence. So we've gone all the way through the tribunal process. We've maybe been told that we've just discriminated against one of our employees, and we've got a 30, 40, whatever £1,000 judgment against us. What do we do if we don't agree? What do we do if we think something has happened? Of course we don't agree. We fundamentally put in a response saying we didn't agree. We'd have accepted it if we knew it happened. But in what situations can we do something about it? So there are a few routes to have a judgment reviewed in the employment tribunal. They match broadly the appeal process in any other jurisdiction. The first thing you will want to do on advice is get written reasons for the judgment. Some judges will issue these automatically. There is time limits for all of these things, by the way, so seek advice, even if you're acting for yourself, on how to do this, because the appeal process is much, much more rigid than the original tribunal system. But request written reasons. You can either do that immediately in the hearing itself, or you need to do it within a couple of weeks of receiving the outcome, which usually just says, either case upheld and judgment or case withdrawn. Once you've got those and you've had an opportunity to review the written reasons, you can ask the original tribunal to do a reconsideration process. This is quite limited. It's only if there's been a procedural mistake. So a good example there would be you didn't get notification of a hearing where a final decision was made, for example, in your absence, and the employee has basically won on a default judgment. That's not the phrase we use, but to all intents and purposes it is. So that's a useful procedural mistake. The employee might have made a mistake in your email address. You never received the response or the original claim form, for example. New evidence has come to light which wasn't available at the time because the other party concealed it. That can give reason for reconsideration. Or there's been a genuine factual or legal mistake in how the case has been handled or judged. Notice none of those are simply we don't agree. And a mistake does have to be a mistake. It's not just we don't agree with how the judge has interpreted that evidence. Formal appeals to the Employment Appeal Tribunal, again, they have a very, very strict deadline that is relative to that receipt of written reasons or reconsideration. A formal appeal to the Employment Appeal Tribunal does have to be on a specific point of law, or that it was sort of completely illogical for the judge to have reached the original decision. That second one, very rare. The first one does happen quite regularly. It could be that you think the judge has incorrectly applied the test for disability. It could be that you think there's a serious question about a new or novel concept that is coming to light that maybe hasn't been addressed by the tribunal system before. So let's not forget the recent transgender case making it all the way to the Supreme Court is a prime example of that. We needed that appeal process in order to have a decision of what is meant by the definition of sex under the Equality Act, and that is what the Supreme Court sort of gave us. And that is really it. You should take specific advice. To be honest, when you're considering going to the Employment Appeal Tribunal, even we would say get a barrister's opinion on this as to the merits and value in doing so before you even think about lodging that appeal. It's a very expensive process. It's a much more formal process than the Employment Tribunal. And it's not always warranted, to be honest, is the short answer. So that is it for me today. Like I say, I was going to do a short bit on outcomes and sort of next steps and what we do to in-house maybe when we've had a decision go against us, but I'll park that for another session. Thinking about it, I may do that on the 9th of July session. I'm deliberately doing that one a little bit later in July. Just to warn you as well, I will probably also pause the session in August. I'm assuming people will be away. We'll have people off our end, so I just think it's probably easier to suspend for August, pick up again in September. If that changes, we'll let you know, try and give you notice of that. As I said earlier, if you've not yet signed up for the mock tribunal and you've enjoyed these 3 sessions on the tribunal itself, great opportunity to come along, have a look, see how it works. We've got quite a fun case study. So please do come along to that if you can. Like I said, there's a few more spaces for it. Those of you who are coming, look forward to seeing you there and coming to have a chat with us in person afterwards and have a proper catch up. Anybody who's going to the insolvency conference that we're running next week, I will be there for that as well. You might well be involved in that one. Otherwise, that is it from me for today. If anybody's got any ideas for any future sessions from September onwards, please do let me know. If anybody's got any questions, as always, feel free to put them in the chat now and I'll have a quick look. I've noticed none seem to have come in as I've been going, so I'll take that as a good sign. Otherwise, that is me done. Hope everybody has a good rest of the day, rest of your month, and I will see you in due course. Thank you, everybody.